Hi, I'm Dan Kuperstein, and welcome to this episode of Compliance Minute. In a move that brings many employers' fears closer to reality, on February 9, 2016, the Southern District Court of Appeals of New York denied Dave & Buster's motion to dismiss in the case of Marin v. Dave & Buster's. As we discussed in an earlier episode, this is a case where a group of employees at Dave & Buster's alleged that their employer violated ERISA when it reduced their hours to avoid incurring increased penalties under the Affordable Care Act. This could be a watershed case for employers that have utilized an ACA liability reduction strategy of reducing employees' hours below 30 per week in order to avoid paying penalties under the ACA's employer shared responsibility or pay-or-play provisions. Let's discuss the key facts here. The plaintiffs in the case claim that Dave & Buster's went to great lengths to reduce the number of full-time employees that would become eligible for their health care coverage. Specifically, the complaint stated that Dave & Buster's, in a, quote, preemptive strike against Obamacare, reduced the working hours of a large number of full-time employees in order to bring them below the 30 hours required to be treated as full-time under the ACA. The class action suit was brought on behalf of the more than 10,000 part-time employees of Dave & Buster's. The claim was filed under Section 510 of ERISA, which, among other things, makes it unlawful for an employer to discharge, fire, suspend, expel, discipline, or otherwise discriminate against a participant or beneficiary for the purposes of interfering with such participants' attainment of any rights under ERISA. Traditionally, these types of claims under Section 510 have failed since the employees had no entitlement to benefits that had not yet accrued under the plan. And because courts have traditionally granted employers great leeway in reducing hours and benefits as business needs dictate. Further, other earlier court decisions have held that a plaintiff must show more than simply a lost opportunity to accrue additional benefits in order to support a claim under Section 510 of ERISA. However, the court here found that the plaintiff had alleged sufficient facts to support a claim that the employer's unlawfully motivated actions did more than eliminate the potential right such employees might have attained to participate in the plans in the future. In other words, facts were alleged that could show that Dave & Buster's intentionally interfered with employees' benefits because of the rising costs from the health plan associated with the ACA. It's important to note that these kinds of actions are quite common. The types of actions taken by Dave & Buster's to reduce their exposure to ACA-required coverage were consistent with the types of actions taken by other employers following the passage of the ACA. While some employers reduced everyone's hours below the 30-hour per week threshold that would qualify such employees as full-time, and thereby eliminate the need to make an offer of coverage under the ACA, other employers restructured their entire workforce to eliminate full-time positions altogether and to only utilize part-time employees. Significantly, the district court denied Dave & Buster's motion to dismiss the complaint. With this ruling, the plaintiffs will now have the ability to pursue their claim. While this by no way indicates that the plaintiffs will ultimately prevail in their lawsuit, it takes these employees much closer to victory, if not much closer to a large settlement. Should they prevail, they may be entitled to a restoration of their health benefits and other lost benefits and wages resulting from their reduction in hours to part-time status. The court's ruling to deny Dave & Buster's motion to dismiss raises significant concerns for not only Dave & Buster's but for all other employers that implemented this commonly utilized ACA liability reduction strategy. As a takeaway, it's important that employers instruct their managers and supervisors not to blame any reduction in hours or benefits on the ACA or Obamacare, whether that's orally or in writing. Such actions may lead to an unwanted ERISA claim. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.